This video will guide you through the process of handling a 401k account after a loved one has passed away. We'll cover everything from determining the provider to exploring your options as a beneficiary. In this guide, we will cover several important topics. First, we'll talk about identifying the 401k provider. Next, contacting the provider will be our focus. Then we'll explore options for beneficiaries and the associated tax implications. This will be followed by discussing the time limits and regulations. We'll also cover the actions to take if there are no beneficiaries, as well as looking into any related life insurance policies. The initial step involves figuring out who the 401k provider is. You should reach out to the deceased person's employer's HR department, as this is the best place to start. They will help identify the provider of the 401k plan. Let's test your knowledge. Where should you start when determining the 401k provider? Is it contacting the provider directly, consulting the HR department of the deceased's employer, or finding the last 401k statement? You may pause the video now to think about the answer. We'll discuss the answer in the next section of the video. The correct answer is to consult the HR department of the deceased's employer. They have the records and access to information that can help you determine the 401k provider. Once you have identified the 401k provider, the next step is to contact them. You'll need to call their customer service and provide essential details such as the full name, date of birth, and social security number of the deceased. Have the death certificate ready, as it's likely they'll request it. Upon receiving these details, the provider will reach out to the beneficiaries, supplying them with the necessary instructions to proceed. Beneficiaries have a few options after being contacted by the provider. They can choose to take the funds as a lump sum, though it's crucial to keep in mind the associated tax implications. Another option is to roll the 401k into an inherited IRA, which may offer more favorable tax treatments. If, however, no beneficiaries are named, the 401k assets will become part of the deceased's estate. Tax implications play a significant role in deciding how to handle the 401k funds. Taking a lump sum means the amount will be taxed, and potentially at a higher rate. Rolling it over into an inherited IRA can avoid immediate taxation and allow for tax-deferred growth. If the funds are part of the estate, it can lead to legal complexities and may affect the overall estate tax situation. In accordance with the Secure Act, beneficiaries must withdraw the funds within a 10-year period. Failing to do so can result in penalties. It's critical to plan withdrawals accordingly to prevent any unexpected charges and ensure compliance with the law. In cases where no beneficiaries are listed on the 401k, the assets automatically become part of the estate. Navigating this situation could be challenging, so it's wise to consult with an experienced estate attorney who can guide you through the necessary legal processes and provide advice on best practices. Finally, it's useful to ask the HR department about any existing life insurance policies. These policies might have a set of beneficiaries that differ from the 401k. Confirm the details and make sure any beneficiaries are aware of their roles. To summarize, start by identifying the 401k provider through the HR department. Contact them to present the required information and documentations. As a beneficiary, understand the available options and carefully consider the tax implications and necessary timelines. Finally, always seek professional advice, especially when it comes to handling estates and associated insurance policies. Thank you for watching. We hope this guide has been helpful. Don't forget to like, share, and subscribe, and please leave your thoughts in the comments below.